the Companies Act, Articles of Incorporation, Section 8, Form of Articles. All right. Subsection 1. Articles of incorporation of a company shall be in the prescribed form and shall set out in respect of the company. Alright, so these are the articles, the information in the articles. A, the name of the company with limited as the last word of the name in the case of a company limited by shares or by guarantee. B, that the registered office of the company is to be situated in the island. C, in the case of a company having a share capital, the classes of shares, I mean whether ordinary, preferred or whatever, if any, and the maximum number of shares, if any, that the company is authorized to issue. So it could be 100,000, a million, 50,000, 5 million, whatever number of shares. D, if the right to transfer shares in the company is to be restricted, a statement to that effect and giving the nature of the restriction. E, the number of directors or the maximum or minimum number of directors of the company. F, any restriction on the business that the company may carry on. Subsection 2, the article shall A, be printed or typewritten or be in some legible form or other form acceptable to the registrar, the registrar, that's the registrar of companies. B, be divided into paragraph numbered consecutively. C, it shall bear the same stamp as if they were contained in a deed. D, be signed by each subscriber of the articles in the presence of at least one witness who must attest the signature. So you must have your signature and a witness's signature on it. Section 3. Nothing in this section shall operate or to prevent the inclusion in the articles of a company of provisions with respect to any matter not required by this section to be included in the articles. Let me read that again. Nothing in this section shall operate to prevent the inclusion in the articles of a company of provisions which with respect to any matter not required by this section. Alright. So other things can be in it, basically. Other things other than what you see here can be in the article. Subsection 4. The articles of a company referred to in section 11, A and B. We don't reach there yet. We just had section, where is section again? Section 8. So the articles of a company referred to in section 11, A and B, shall state that the liability of its members is limited. Alright, limited liability. I look up the term limited liability. I see this in Investopedia online. It says limited liability is a type of legal structure for an organization where a corporate loss will not exceed the amount invested in a partnership or limited liability company. In other words, investors and owners' private assets are not at risk if the company fails. Alright, so if you put in $100,000 in the company and the company fails, no one can come to you and take more than that $100,000, right, and say you must pay us back. No person who you might have borrowed from, or the directors might have borrowed from, can come to you and take back more than the $100,000. So your belongings, your assets, what they can take from you is limited to what you had invested. Alright, so that's limited liability. Alright, so here, subsection 4, again, the articles of a company referred to in section 11A and B shall state that the liability of its members is limited. Subsection 5, the articles of a private company shall contain the matters specified in section 25, subsection 1. Subsection 6, the form of the articles of A company limited by shares, and B, a company limited by guarantee and not having a share capital, and C, a company limited by guarantee and having a share capital, D, an unlimited company having a share capital. Alright, so you have different types of articles for these types of companies. These companies, these articles may be respectively in accordance with the forms set out in tables A, B, C, and D in the first schedule, except to the extent that they were excluded in whole or in part or modified. So when you come to the table, we will see the form of these articles. So those articles may be respectively mean in the same order that they appear here, in accordance with this form set out in those tables. Subsection 7, a company having a share capital shall, that means a profit-making company set up to make money, having a share capital, shall, where applicable, they shall file a document with the registrar setting out the following. A, if 2 or more classes of shares are issued, the rights, privileges, restrictions, and the conditions attaching to each class of shares. And B, if a class of shares may be issued in a series, the authority given to the directors to fix the number of shares in and to determine the designation of and the rights, privileges, restrictions, and conditions attaching to the shares of each series. Alright. Section 9, restrictions required in case of unlimited company or company limited by guarantee. So these now don't apply to the limited liability company. But let's see what they say. Subsection 1. In the case of an unlimited or a company limited by guarantee, so remember the company limited by guarantee is a non-profit. Right? Yeah. So, in the case of an unlimited company or company limited by guarantee, the article must state the number of members with which the company proposes to be registered. And if the company has a share capital, the amount of share capital with which the company proposes to be registered. Alright, now we know that the company limited by guarantee is a non-profit organization, but here says a share capital. What is the share capital? I looked up share capital and I seen Investopedia online. It says, what is a share capital? Share capital is the money a company raises by issuing common or preferred stock. The amount of share capital or equity financing a company has can change over time. Alright. The term share capital can mean slightly different things depending on the context. Accountants have a much narrower definition, and their definition rules on the balance sheet of public companies. It means the total amount raised by the company in sales of shares. That is the share capital. So a company share capital is the money it raises from selling common stock or preferred stock. It authorized share capital is the maximum amount a company has been approved to raise in a public offering. A company may opt for a new offer of stocks in order to increase the share capital on its balance sheet. Alright, so basically the share capital is the money that the company raises. Anyway, section 2 or subsection 2 of section 9, where an unlimited company or a company limited by a guarantee has increased the number of its members beyond the registered number, it shall, within 15 days after the increase was resolved on or took place, it shall give the registrar notice of the increase, and the registrar shall record the increase. That means the date when you hand in that notice to the register, you fill in the appropriate form and hand it to the register. It should not be more than 14 days. That 15 days it says. That section that it says this took effect on this date, make sure you hand it in less than 15 days after that to the registrar. That would be in Kingston or Montego Bay. Alright, section 3. If the fault is made in complying with subsection 2, right, you did not notify the registrar within 15 days, the company and every officer of the company who is in default shall be liable to a fine not exceeding $50,000. Right, so you've been warned. Section 10, alteration of articles by special resolution. Alright, now before we go on, let's look at the meaning of special resolution. Now I look this up online. It says, what is a special resolution? Special resolution are also known as extraordinary resolution, are needed for more important decisions or those decisions affecting the constitution of a company. So it might adjust the articles of incorporation. These require at least 75% of the shareholders or directors to agree, and in some situations as much as 95% to agree to that decision. So you'd have a meeting and make note that we resolve to adjust the articles of incorporation to include or to make the following changes, whatever it is. Alright, subsection 1. Subject to the provisions of this Act, a company may, by special resolution, alter or add to its articles. Subsection 2. Any alteration or addition so made in the articles shall, subject to the provisions of this Act, be as valid as if ordinarily contained therein, and be subject in like manner to alteration by special resolution. Right, so those matters deal with the articles of incorporation. Next time we will look at registration of the articles.